Good day, and welcome to Family Matters, the podcast where we dive deep in the world of divorce and family law. I'm your host, and today I'm thrilled to introduce you to a law practice, Stearns-Montgomery Proctor, a family law firm that was founded in 1988. Stearns-Montgomery Proctor is dedicated to providing competent legal advice and advocacy in the complex realm of family law. Expertise spans various issues, including divorce, child support and custody, alimony and spousal support, paternity and father's rights, and adoption. With over 3 decades of experience, the team has witnessed the evolution of family law and has developed a profound understanding of its intricacies. The team of attorneys focuses exclusively on divorce and family law matters, allowing them to offer specialized services tailored to your specific needs. Having been deeply involved with the legal community for many years, their familiarity with the system and the players involved enables them to navigate your case with confidence and provide you with realistic expectations. Join us on Family Matters as we explore the various aspects of divorce and family law, where we share valuable insights and provide guidance to empower you through your legal journey. Today we will interview Randy Sabatini, a partner at Stearns-Montgomery Proctor. Randy grew up in Michigan. After leaving the cold to attend law school in Atlanta, he decided to stick and has been there ever since. Randy practices family law and has done so for more than half of his legal career. Randy's clients find him first and foremost to be a good listener. He helps them feel comfortable, to find a common point of reference, and then to set a process to help them achieve their goals. Through a very emotional time, he remains calm and unflappable, representing their best interests through a productive discussion rather than conflict situations. With a passion for mentoring sports, Randy has spent the last 25 years coaching various sports such as baseball, basketball, soccer, and lacrosse. Randy, welcome to Family Matters. We look forward to our discussion today. Could you please talk us through the difference between a contested and an uncontested divorce?
Sure. We often see or have consults reach out to us and say, I would like to file for an uncontested divorce. Well, that's unique because you have to have all of your work and your settlement done prior to. So, an uncontested divorce is where the parties come to an agreement on all issues prior to filing the divorce. So, for example, if it's a custody case, they have a parenting plan that's already decided the issues of legal custody and physical custody. And they executed a parenting plan that sets forth who has the children primarily, or if they have the children jointly, and what the other parent's visitation time. They've also settled all issues of their divorce that are related to financial matters, such as child support, possibly alimony, equitable division of assets, and they've executed a settlement agreement that outlines the terms of their settlement. They may have executed, depending on the county, what's called a child support addendum that will reference the amount of child support, when child support's paid, also address issues as who's paying the health insurance premium for the minor children, as well as how we're dividing non-covered health expenses, along with a child support worksheet. And the child support worksheet is required by Georgia, and it's going to set forth how the parties arose at or the calculation for child support. If the parties have signed all those documents, then they have the basis of an uncontested divorce. And then you file the petition. Always in Georgia, the attorney is only going to represent one party. So someone's the petitioner and someone will be the respondent. You file the uncontested divorce with all those documents. You'll have to take a divorcing parent seminar, both parties, and within 31 days, you're eligible to file what's called a motion for judgment on the pleadings with the court. And on the 31st day is the first day you can file that. And in essence, you're asking the court to sign off on the settlement agreement, incorporate that into the final judgment decree, review and accept the parenting plan and child support worksheet and possibly child support addendum and incorporate those in the final judgment decree, and actually enter the final judgment decree of divorce, all without anybody having to appear in court. The problem is that when people will call for that, what they really mean is, I want my spouse to agree to all these terms up front. And And so within the first 5 minutes of a consult, when we ask, so have you discussed these terms with them? Absolutely not. But my friend said I should go for an uncontested. And realistically, you'd want an uncontested if you can, by chance, do it. A, it's less expensive. Now, contested divorce means that for one reason or another, you haven't reached a settlement. Doesn't mean a settlement couldn't be imminent, but you need the court's assistance. So, contested is merely filing with the county in which the divorce is going to be held, having the other party either served by a sheriff, served by a process server, or sign what's called an acknowledgement of service, the least adversarial way. And now you've started the case. And then during the case, you might do it for different reasons. And shortly thereafter, if the parties can come to terms, usually both parties will have counsel, then you can turn a contested divorce into an uncontested matter. But from the get go, you can't just file an uncontested divorce unless both parties are in agreement or close to an agreement on all terms.
And just a follow-up question on that one. So let's say I come into your office and I have a basic understanding of what an uncontested divorce is, and I've done my homework, and I arrive in your office and I've got all my documents in place, and I've put together a checklist and what I propose this uncontested divorce to be. You would still need the second party or the other party to have done exactly the same thing. Is that correct? So it couldn't be that you've got all of your affairs in order, they don't have theirs in order, but we can still file for an uncontested divorce.
Well, no, I may have half of what I need. So, what I would have is you're still eligible for an uncontested, or the case could still be an uncontested divorce, is if our client who came to us with all the paperwork would say to us, I don't need any other financial information from my spouse. I know his income or her income, so we can calculate child support. I know all the assets. Okay. I know how much he has in his retirement account because I have access to everything, or we've even shared it. So I know the values of all of our assets. I know the value of our house. And so in that case, it could be a candidate for an uncontested divorce because with all the information, we could draft all those documents, the petition for divorce, the acknowledgement of service, settlement agreement, child support worksheet, and a parenting plan, assuming that there were children. And so, from the information provided by our client, we could prepare everything as an uncontested divorce. We have a cover letter that we would put on that uncontested package, and which acknowledges that we represent only our client, that it's our understanding they want an uncontested divorce, and here's our terms of settlement. And obviously, in the document or in the cover letter, it says if you've engaged counsel, please have your counsel reach out to us. And often on those situations that the other side will either negotiate on their own, they'll contact the other side and say, yes, I agree to these terms if you make these changes, or they'll retain counsel and the other attorney will contact us and we'll start to negotiate, but it's all prior to filing. So we would still consider it an uncontested divorce candidate. And if we're able to come to a mutual agreement and reach a settlement and sign off on all the documents, we then still file it. The parents will still have the obligation to take the divorcing parent seminar, and they'll still be eligible within 31 days of filing of the divorce to submit a motion for judgment on the pleadings. So even though we get all the information from one side, that may be sufficient to move forward with an uncontested divorce.
And I think that's important to know. It's just that you can try and be as prepared as possible so that when you come in, there isn't an opportunity or a chance for you to pursue that route. And that, I think, is really important.
More information is always better. That's saying the more you can give to your attorney upfront, A, is helpful to get more information. Your attorney will be able to give you more counsel based on the information provided. B, it saves you money. The more work you're doing to give us paperwork, the less we have to do. And a lot of what we're doing before we get to negotiation phase is truly acquiring information, whether we're acquiring it from our client or we have to acquire it from the other party. And sometimes, if the other party is not being very compliant, we might have to acquire it from a third party, a bank, an employer, just to make sure we secure the information so that we can start to prepare a settlement proposal.
Okay. So you mentioned that one of the greatest benefits of an uncontested divorce would be the cost. What are some of the other benefits of pursuing an uncontested divorce?
Well, there's the, I would say, emotional capital of a divorce. A lot of people, once they're ready to file, it's a transition and it can be painful. And their choice would be to make it happen as quickly as possible, especially if you have children. You don't want to drag them into a litigation. So there's an emotional component of saying, I want to get this over with. And then you don't have to go to court, because once you file a contested divorce, what you've basically done is you've given authority to the court system. Now you have a new set of rules. You have to do everything that complies with court orders, and you have court oversight. And so now you have to be prepared to live within a really tight structure from the commencement of your lawsuit to the end of it. And for a lot of people, while we guide them through it, it's still a new journey, and it can also be a highly stressful journey. And then thirdly, it becomes more costly, significantly more costly, which can add to the stress of it. That's why we try to streamline it. So if you can settle prior to court and make it have an uncontested divorce, it is better for many reasons, both financially and emotionally for the client.
Okay, perfect. At what point does an uncontested, so let's say we've now decided we're moving forward with an uncontested divorce, everything's in place and the path forward is looking good. At what points could that change from being an uncontested divorce to then becoming a contested divorce? How does that happen?
Uncontested may be moving in the right direction until the other side says no. I'm not going to give you primary custody. I want 50-50 custody. So you hit a logger jam on one point, or no, I want to keep the house and buy out your share of the equity. I don't want you to keep the house. I want the house. And you can't come to an agreement. Well, that's very clear. If you can't come to an agreement, then you're in a stalemate. So then you have to go to a contested divorce in order to facilitate the process. Because when you file for divorce, the other side has a duty to answer, and they'll usually file an answer and a counterclaim within 30 days. And they also hire counsel if they haven't already. Then you have 6 months from the date the answer is filed to conduct your discovery, which is your fact finding process. And that's also a primary reason why people come in for an uncontested divorce and then realize that they need a contested divorce. And that's because they need an avenue to secure financial records to ascertain what are the assets. Some people don't know what they have, or some people, there's a lack of trust between them and their spouse. So they'll say, well, my spouse says this is it. Do you trust the spouse? Well, no, I don't. Well, then you have one avenue ahead of you, which is the discovery process. The court's going to require that there be financial transparency. So, in terms of that, that's one reason why, even though you think you want it uncontested, you need it contested, because you need to discover. You need that domestic relations financial affidavit signed under oath from your spouse identifying all the assets. Then you want to be able to review 5 years worth of retirement account records to say, has anybody money moved out? Oh, there was a withdrawal of 200,000. Why was there a withdrawal? Where did it go? Oh, it had to go into this bank, but that's not listed on the financial affidavit. Well, these are all assets. So you end up uncovering information just so that you have an idea, or you can confirm what the marital estate is. Some parties, because there's a distrust between spouses, will say, I don't know if he's hiding money, but I want to check, or she's hiding money, or if there's accounts that are undisclosed. So that's when we say, well, uncontested isn't going to help you because that's more just a guess. Say, I don't know what my spouse has. This is what they're offering. Is that a good deal? And we can't say it's a good deal because we don't know what the marital estate is. We can tell you if you just want to accept as is and move on and you're happy with that, then that may accomplish your goals. But we won't know if it's a good financial deal until we do the discovery and review the financial records and income records. So often, when a spouse either doesn't have the information or there's a lack of trust, you have to go contested. You go through the compulsory process of discovery. And if a party doesn't want to provide something that the court deems they should, you can file a motion to order them to provide discovery. And so either A, you uncover information, or B, you allay fears. Once the client's seen the financial affidavit and they've seen the records and they feel more comfortable. So now I'm ready to negotiate. I've confirmed there's no other assets. Other times there may be a business involved, and the business was started during the marriage and it is a marital asset. Well, what's the value of the business? Well, my spouse says the business isn't worth anything, right? And I talked to my neighbor, and he sold a restaurant and said, my husband's restaurant should be worth $1 million. What does the neighbor do? Oh, the neighbor's a doctor, but he has no idea about business values. But he just thinks that. So in that situation, we may need to have a business evaluator. There are certain forensic accountants we use in family law, and there are about 4 or 5 in the metro Atlanta area that we all share and use that are highly respected. And through the discovery process, we get the financial records for the business, and we ask them to do a business evaluation. Everything from medical practices to widget shops, a manufacturing company, to a shoe store, any type of business. If there could be some asset, you want to determine the value, because that value go on the marital balance sheet. Now, a party may not want anything to do with the business, but if we're trying to equalize assets, you don't want to neglect anyone, but it's a process to put a value on it. You want to be accurate. So that's another reason that we're going to have to go into contested, because we need to do a business evaluation. Now, it's possible to do it pre-filing, but more often not, it's done once it's a contested divorce.
How common is it for couples who have children to go the uncontested route? So I know you would have to have a parenting plan in place. You would have to have the supports. You would have to have discussed. There's so much that you would have to have discussed. And I know that you mentioned that they would have to complete a child or parenting course. Is that correct?
Yeah, the parenting seminar for divorcing parents can be conducted anytime prior to the filing of the final judgment and decree. For an uncontested divorce to occur with custody, the parties have to already determine under joint legal custody who's going to have final decision making on areas of education, non emergency health, religion, and extracurricular activities. More often than not, the older the children are in a divorce, the less likely or less important those issues are. Because your children by 14 or 15 are already involved or at a school, whether it's public or private. Um, God willing, they don't have any health issues, so there's no health matters. It's just ongoing checkups. They're involved in their religion, and often courts will say each parent can take the child to their house of worship if they're different religions on their respective weekends. And then they're involved in their extracurricular activities. It's different when they're younger. So when kids are younger, a lot of dads say, I want, to sign my son up for baseball. I don't want to lose that right. So that becomes more of an issue earlier when the kids are younger. So you see uncontested custody matters less likely with younger kids. More often than not, you can see it with older kids, but there has to be dialogue between the parents. And again, you often run into that same situation. I want an uncontested and I want primary custody of my kids. Well, that could be good. What does your husband want? Oh, he wants primary custody, but I want it uncontested. Well, you know off the bat that that's not going to happen. But it is possible, and parents can dialogue beforehand. And sometimes it's just a function of you know both parties' work schedules. If it's a father who's going to be the non-custodial and he travels Thursday through Friday, he's not going to have 50-50 parenting time. Or primary, if he's out of the state with younger kids, court's going to usually allow the primary parent, absent some kind of negligence or health issue, to be the primary parent. But at times, the parents come to us and they say, we've already decided what we're going to do. So you know who's going to have final decision making and how we're going to have who's going to be the primary and what the non-custodial parents parenting time. And they have the basic facts, and then we create the parenting plan, and maybe they alter some holidays, but they're able to sign it, and so you've got that piece ready for an uncontested.
And I suppose it's important to note or to remember that in a contested divorce, when it comes then to your parenting plan and it comes to what the future for yourself and your children is going to look like, in a contested divorce, you're handing that decision over to the court process, and you're not completely in control of what that looks like.
That's an accurate statement. I would say up until the time that you have a trial, you're 100% in control because you're free to negotiate and try to come to terms with a settlement. More often than not, in a custody case, the court will call the case in for what's called a pretrial conference prior to trial or a calendar call. And very often, judges will plant that seed. There are a couple of judges that were real candid about that. One retired judge used to tell everyone he was a district attorney and he went through a divorce in his county and he practiced before all the sitting Superior Court judges, and there was no way he was going to allow them to determine when he got to see his kids or not. And often judges will tell you, because you're counselor there and parties, why you want me to decide when you see your child and when you don't. I don't know. And also, when you put it in our hands, you lose control. And you often hear that at mediation. Like, try to settle here, because once you go for a judge, you lose control. Now, judges do mostly get it right, but sometimes they don't. And when they don't, you've lost your opportunity. So it's a very accurate statement to say, once you get into the court system, and especially if you get to trial or a temporary hearing, you put it in the hands of the judge, they're going to render a decision either on a temporary or final basis, and you do lose all control of it. And I had one judge once say that she knows that she's done a good job when both parties leave her courtroom unhappy.
It's a sobering thought when you think of it in those terms. It's a big motivator to try and have something in place to get that.
And that's why a significant portion of cases that may start uncontested become contested because they can't negotiate or settle on all terms. They get to mediation. And you get to mediation, there's so many good mediators in Georgia, and you get a lot of cases solved either on a temporary basis, partial final basis, or in full, because the parties realize this is the last juncture that you're in control. And so I think and you have the introduction of a third party neutral who is a mediator, most likely a family law practitioner who's been in the trenches before, who knows the judges you're going to go before, and reminds the parties with counsel present, you're in control now, try to find compromise. In essence, you're going to end up compromising the rest of your life, especially if you have children. You have to co-parent. Some people think the divorce is the ending. When you have children, it's just the new beginning. It's a new beginning. So be prepared for it. Start compromise now. In certain situations, it works out.
Okay, so What happens if, so let's go back to I walk into your office and I'm about to file for divorce, and I believe that it needs to be a contested divorce. At this particular time, I can't see that this is going to be able to be an uncontested divorce. Is there any point during that process that I can change my mind, or that we could change our minds, and we could change it over to an uncontested divorce?
Well, once you file, then it's contested, and if you settle it, it's now uncontested. So, by virtue of filing, again, sometimes you have to file to ascertain information. So, even though it's in an adversarial setting, plaintiff versus defendant, petitioner versus respondent, you're filing because I need to get certain information I couldn't get before, but the intent is let's try to get it settled. We don't need to rush to court. It sounds ironic, but a lot of people file and hope they never go to court. They just want to get that information that they need with counsel to make an educated decision or offer or acceptance on someone else's settlement offer. So it doesn't really convert back, you just settle the case. Sometimes when people come to us and say, I'm ready to go, it's contested, we're going to fight for everything. And when you have that consultation, you find out, well, where are you on custody? Oh, well, I don't want that. I want this. Oh, there's no issue there, legal custody. What about physical custody? Oh, no, I can only my work schedule, long weekends, week on, week off in the summer and holidays. Well, that's probably doable. And child support, here's my income, here's her income. We're W 2 employees. We've made the same amount. We work with the government. Child support's there. Alimony. What do you want to do? We both want to sell the house. So what's the issue? I want the dog. I want the dog. Right? It was a gift to me. The dog's 17 years old, and if it's got 5 more days, I want the dog. Well, they're coming in for contested, but you're going to say, most likely, or I would advise them, let's draft this as an uncontested. And let's see if we can resolve the issue of the dog. And believe it or not, I've had cases where the parties treat the dog like a child and have like a dog custody plan. We're going to share the dog and we're going to share expenses and vet bills, and you pay for when you feed it, and we exchange at the park every other week. And so you can do it. But parties will come in because they think it's a divorce. I have to fight. So we have to make it contested. And you advise them, let's try it uncontested. Let's try to negotiate it prior to, so you save money. But once it's filed, at any point in time, you can settle the case and convert it to, then it becomes uncontested. There are some cases that go up to the day of trial. So it's contested and you're ready for your day of trial. You're ready to go to war. You have your experts, you have all your evidence, you're scheduled for a 3-day trial. And the parties wake up that morning and maybe have a call between us. And you really want to do this? Do you want to get on the stand? And you get a settlement on the proverbial courthouse steps. So anytime up until the judge says, let's start. There have been cases also that settle middle of trial. You always want to avoid trial if you can, because sometimes there are emotional scars from trials that don't heal, because it can be rather harsh. People say things about their other spouse. And that's another piece of, do you want to go through that? And counsel are ready to do that. And then we move to the next case. And parties often will be ready to go. They want to go to trial. And then the longer the case goes, depending on the issues that are pending, some of the anger dissipates, some of the rancor dissipates. And especially when you have kids and you realize Johnny and Susie need 2 parents loving them up. And at the end of the day, there's one pie to split. Why are we giving it all to the lawyers? There's that economic component. And so often contested cases turn into uncontested or settled cases for all the reasons I mentioned.
All right. So, very quickly then, just to sum up some points, if we could possibly just, if we're looking at contested versus uncontested, and you have a client or potential client sitting in your office, when are you going to advise them to go contested? When would you advise them to go uncontested, if you would, on either side? And then what advice would you give to them? Just very quickly, a couple of pointers as they prepare to start this journey to make this decision.
Uncontested would be a function of how much information you already have, how far along you are with dialoguing with your spouse on the process, and how close you are after that dialogue. So there are often times that someone comes in for contested where I'll mention we might be able to do this uncontested. However, when you come to the office and you don't have a lot of information and there has been no dialogue and you have not discussed it with your spouse, so there's going to be an element of surprise. It's going to be contested. General rules will prevail. Acquire all the information that you have right now readily available and get that over to your counsel. Whoever at our firm's handling the case, give them all the information. 2, de-escalate the drama. There is one emotion that the court does not do well with, and that's anger, especially when their kids are involved. So no matter how mad you are at the opposing side, no matter how hurt you are, how they've treated you unjustly, that will eventually come out. But just because you file for divorce doesn't mean you have an open door policy to unleash the cannons on the other side. Because the courts actually want you to do the opposite. They want the parties to show decorum and respect and be cognizant that children are sponges and that they're going to absorb everything, especially if you're in the house. The courts issue what's called the Domestic Relations Standing Order. And there's a form of that in all the counties. And that document, kind of an admonishment to the parents, don't harass each other. Don't dissipate assets other than the ordinary course of business. Don't get the children involved. It's like the do's and don'ts of going into it. So it's often very challenging to tell a client, this is the most emotional transition you're ever going to go through, short of losing a loved one. But it's the loss of a relationship. So it's painful, and it's emotional, and it's raw. And your attorney's telling you, stay calm, don't get angry, don't expose all your feelings. Well, there are healthy ways to do it. If you're having a hard time with anxiety, find a therapist. We often tell people start counseling. If the kids have already been caught up in a lot of mom and dad's drama, or mom or dad and dad drama with same-sex marriages, try to get the children, depending on their ages, if they're real young, play therapy, or if they're older, into therapy. So engage yourself and prepare to take this step by step. A lot of people want to go through a divorce like it's a sprint. Let's go. I want it over with, done. It's more like a marathon. Pace yourself. If we can cut off miles and end it early, that's our goal. But emotionally, prepare for something long, something that can be painful. And if you can de escalate at all times, gather information. Remember, if we're in court, we're trying to acquire information, or we're trying to get assistance from the court if somebody is, one of the other parties is doing something improper. There's a time manner. You have to ask for a hearing. The court gives you a hearing date. A lot of parties, they're a little dismayed when they find out about the court process, that it's not like going into Publix and going up to the butcher counter and say, I want your freshest T-bone. And then you get it within a matter of minutes. You ask for a hearing, and there are all these other cases. It may take time. And, what's an emergency to get down an emergency basis? What's the cost function? So what we try to work with is we guide our clients. We give them reasonable expectations of what to expect and say, we're going to guide you through this process. And the courts will reward you at the end if you stay calm.
Sorry, I just wanted to add to, I think that that analogy of a marathon is so important, and to remember that the marathon, the the process of the divorce is only the beginning of that marathon, and I think you need to keep that in mind. And the end goal is, particularly with children, it's a long time, and you want to run a good marathon. So to bear all that in mind at the starting point and to pace yourself correctly for that journey, I think is so important.
I have found that children will gravitate towards the calm by nature. And I advise all my clients who have small children what you do now in post divorce paves the way for the rest of your life. Because when they're 18 and they're not governed by a court order and they're adults legally and they can go and do whatever they want to do, you hope that all the work you've done while you were married and post marriage and building the relationship with your child is something that lasts them not just after 18, but for the rest of their life. Because the window of time you have them in the house is very small for most families. And when they become adults, you want them coming back on their own free will. Well, no child asks for a divorce, but if you can provide calm and that safe landing spot for them post divorce, you're pretty much ensuring that you're going to maintain a relationship with your child for the rest of your child's adult life. And that gives them a focus of it's important to run this marathon because if you have adult children, you realize you never stop being a parent.